Hello, it's Simon here from Confidence Wills, and I'm drinking coffee and about to publish this week's blog, which is called Is a Last Will and Testament Legally Binding in the UK? Well, the simple answer to this question is yes, subject to certain criteria. And these criteria are pretty self-evident. The first is the document has to be drafted correctly. Now, at Confidence Wills, we have databases of clauses and wordings that have been tested in case law and we know to work. So we ensure that drafting is always done properly. Secondly, the person making the will has to be of age, so over the age of 18 in English law, and have mental capacity, so they have to be of sound mind. Now, the threshold for mental capacity in making a will is actually pretty low. It includes things like knowledge broadly of what's in your estate, knowing who your immediate family is, things like that. It refers back to a bit of law called Banks and Goodfellow. Finally, it's very important that when making a will, somebody making a will isn't unduly influenced to do so. Now, undue influence really amounts to being threatened, coercion. Everybody influences everybody all the time. But if somebody puts a gun to your head and tells you to make a will, that will is vulnerable to successful challenge later. Now, it's worth noting that just because a will in and of itself doesn't fall down, it's perfectly possible for individual gifts in a will to fail for various reasons. Now, there are a number of these reasons. The first one, perhaps the most pernicious one, is where a beneficiary of a will or their spouse actually witnesses the document. They can end up forfeiting their gifts. Now, this is nasty because it's something you don't necessarily find out until it's too late when the will is read. Another reason a gift may fail is, of course, if you divorce a spouse. Any gift to them will fail. The will isn't revoked on divorce. It's just treated as though that spouse has predeceased you. Obviously, there are various reasons rooted in the idea that, a piece of property isn't in the estate for a gift, so it can't be gifted. There isn't enough money to make a gift, so that gift can't be made. Essentially an absence of stuff, as it were. Gifts can fail on that basis. And, perhaps the most obvious one of all is unlawful killing. So if a beneficiary of a will unlawfully kills the testator, the person making a will, they can forfeit their gifts, unless they can prove that it was by reason of insanity, as we learn from case law. So that's it for today. I don't want to go on for too long. You're very welcome to read the blog. If you want to find out more, you can subscribe to our videos, you can read the blogs, or you can visit our website and book a free consultation without obligation. The website's www.confidencewills.co.uk. That's www.confidencewills.co.uk, and I look forward very much to speaking to you all soon. Take care.